And now, without further ado, I give the floor to Massimo Introvigne, who will speak about the relations with ex-members, sexual abuse, and what are these issues. Massimo, you have the floor.
Thank you. I hope the PowerPoint is visible. Otherwise, I will ask the webmaster to advise me. And I believe that the question we are discussing today has a general relevance that goes beyond the Jehovah's Witnesses and actually involves crucial issues in the sociology of religion. My starting point today is a well-known book, at least in Germany, Die Macht des Heiligen, published in 2017 by German sociologist Hans Joas. So again, my starting point is Hans Joas' book, Die Macht des Heiligen. This book deals with the most discussed issue in sociology of religion, secularization. Is it possible to have a society without religion? Many sociologists will answer no, but based on the experience of some Western countries, particularly Europe, Joas would say it's possible to have a society with minimal presence of institutional religion. However, elaborating on Durkheim, Joas says it's not possible to have a society without sacralization. So if there is a little religious sacralization, there will be sacralization of the state, not only in totalitarian countries, or sacralization of the person and of her human rights. Now, it's possible that an individual would survive comfortably living within the three sacralizations, and that's why I'm showing you an image of Alcide de Gasperi, who was Prime Minister of Italy immediately after World War II for many years. Surely he partaked in religious sacralization. He was such a pious Catholic that is being considered for beatification by the Catholic Church. At the same time, he certainly regarded himself as an Italian patriot, and he was also an enthusiastic supporter of the then newly proclaimed Universal Declaration of Human Rights. However, there are cases where the three sacralizations, the religious one, sacralization of the state, sacralization of the person, and human rights may enter into conflict, particularly nowadays when there are continuously new rights advocated for and in their own way sacralized. For instance, feminists claim that it's an important human right for women to have equal access to all positions and offices, but several religions would say that the priesthood and other offices are reserved to males. LGBT activists may see religious teachings that homosexuality is a sin as infringing their rights to be respected and not to be discriminated, and so on. So the sacralizations can coexist, but they may also enter into conflict with each other. One theologian, and I believe whatever you may think of his pontificate, surely he is unsurpassed for depth of understanding and books written, perhaps as a Catholic theologian. Cardinal Ratzinger rather Pope Benedict XVI, he discussed several times the conflict between old rites and new rites, but I believe what is interesting here is the distinction between individual and corporate freedom of religion. And Ratzinger noted that many people will be in favor, with limits, of the idea that individuals have a freedom to believe or not to believe, but it's much more difficult to find people agreeing that corporate religious bodies have rights of their own, and the individual and the corporate religious liberty are not exactly the same. Now, a few months before Pope Benedict XVI resigned, he approved a Vatican note on two European Court of Human Rights cases then pending, and the one of main interest here is Sindicatul. And in this document, the Catholic Church expressed its support for the right of the Romanian Orthodox Church to take action against priests who had formed a non-authorized trade union of priests, and to ask the Romanian government to deregister the union. And in the end, the Grand Chamber of the European Court ruled in favor of Romania, the Romanian Orthodox Church, and in the sense recommended by the Vatican. Now, the point here the Vatican wrote is that relations within a church are outside the province of the state. If there are disputes within a church, what is allowed, what is not allowed, should the priests have the right to form a trade union? Should they not have this right? If they do this, should they be excommunicated or expelled or not? All this, it's a matter for internal religious discipline. If somebody is not happy, he or she can leave a church, perhaps establish a new religion, but cannot go to a secular court to have a secular court decision about the internal rules and proceedings of a church. Of course, in this case, the Catholic Church took a position in favor of the Orthodox Church in Romania, whose organization is quite similar to the Catholic Church. I don't know whether they would have taken the same position at the case involved the Jehovah's Witnesses or another religion very much different from the Catholic Church. But it is true that the Catholic Church, that the Jehovah's Witnesses have acted as the proverbial canaries in the coal mine. They have fought pioneer cases, landmark cases, already mentioned today, about the right to conscientious objection, not to salute the flag, not to sing the national anthem, and they have asserted the religious freedom of everybody by winning these cases. And from the framework of this paper, here we see Jehovah's Witnesses as a group who have a very strong view of religious sacralization, acting against the expanding sacralization of the state. The state will ask you to salute the flag. They will say, no, the only sacralization we recognize is religious sacralization. For us, sacralization of the state is a form of blasphemy against God. Now, this fight is not over. We see it goes on in Russia. It goes on in China. It goes on in South Korea, where in 2018, the Supreme Court ruled in favor of conscientious objection by the Jehovah's Witnesses, but yet the cases are still not solved. But in all these cases, including what's going on in Russia and China right now, the fight is for individual religious freedom. So the Jehovah's Witnesses may have a lot of sympathy and a lot of allies, including some strange bedfellows, in the shape of libertarians, some of them atheistic, and they see this fight against the sacralization of the state in favor of individual religious liberty as something very much positive. But when the Jehovah's Witnesses assert their corporate religious liberty, most of these allies disappear because, as we saw before, corporate religious liberty is a much less popular cause than individual religious liberty. Yet it is important, and a key point in the Grand Chamber European Court of Human Rights decision in Sindicatul, that's the Romanian Orthodox priest case I mentioned it before, is that Article 9 of the European Human Rights Convention should be interpreted in the light of Article 11 of the same convention. And Article 11 is protecting associations, all associations, from arbitrary state interference. In other words, with limits, of course, associations cannot beat or kill their members, but associations have a large latitude to decide who should be a member and who should be expelled. If you have a political party, if you are a member of the Conservative Party in the UK and you campaign for Labour, you will probably be expelled and you cannot go to a court of law saying your human rights have been violated. If you are a supporter of Real Madrid and you go to the street to cheer for the arch rival Barcelona FC, you will probably be expelled from the supporter club and you cannot ask a court to reinstate you. In the words of Sindicatul, where the organizational life of a community not protected by Article 9, that means the article on religious liberty, all other aspects of the individual's freedom of religion will become vulnerable. Putting less juridical or legal terms, individual religious liberty is a joke if corporate religious liberty is not protected at the same time. Individual religious liberty is in serious danger if you do not also protect corporate religious liberty. Now, there are 3 points which are now very much questioned, and where once again the Jehovah's Witnesses are at the forefront of, at the cutting edge of religious liberty fights, which today means defending in the West, in democratic countries, not in Russia or China, where also individual rights are in danger, but in democratic countries it means defending corporate religious liberty. And the first is the right of Jehovah's Witnessing to disfellowship, something in other contexts will be called expelling or excommunicated members. And I will not go through the different decisions you see listed here, which come from very different jurisdiction, US, Italy, Canada, UK, and there are more, but this paper will be published in November in the Journal of Cesnur, which is a free online journal downloadable at cesnur.net. And you will find there all these legal references. Besides, Most of these decisions are also relevant for the Spies case in Switzerland, and so you will find them quoted in the book The New Gnomes of Zurich. I mentioned it before, and which is now at Cesnur.org, which is different from Cesnur.net, available for free download, and it will be available in several languages. Basically, in the terms of the Supreme Court of Canada, which ruled on a case in 2018, the procedural rules of a particular religious groups involve interpretation of doctrine, and sociologist Max Weber would have agreed that the organization of a religion is in itself theology. So to interfere in the internal organization of a religion is tantamount to interfering with its theology. So how the ecclesiastical courts, called judicial committees of the Jehovah's Witnesses, proceed in judging who should be disfellowshipped, what is their procedure, how they work, you cannot go to a secular court and ask the secular court to second guess the decision of the judicial committee. If you say that your religious freedom has been violated, the secular courts in many countries have answered that this is not the case, because you are free to join or not to join the Jehovah's Witnesses. If you don't like the judicial committees of Jehovah's Witnesses, you can establish another religion, perhaps call it the Reformed Jehovah's Witnesses or the anti-Jehovah's Witnesses. That's not important. But you are free to join or not to join, to leave or not to leave the Jehovah's Witnesses. But once you are a member of the Jehovah's Witnesses, you are subject to the jurisdiction of their judicial committees. And this jurisdiction you cannot appeal to a secular court against. Now, a delicate point, and one very much in the media today, is that once you are disfellowshipped, the interpretation of the Bible by Jehovah's Witnesses is you should be shunned. Now, it seems a very new matter. Should we protect the rights of the individuals against shunning, or should we protect the right, the corporate religious liberty of Jehovah's Witnesses to shun? But that was already decided in a landmark US decision in 1987, Paul versus Watchtower Bible and Tract Society of New York. This is the mother of all decisions on shunning, and that's been quoted in the US, occasionally in other countries ever since. And this decision says shunning is a practice connected with the interpretation of the Bible by the Jehovah's Witnesses, and courts cannot say whether this interpretation is right or wrong. Secular courts cannot, nor can they tell the Jehovah's Witnesses how they should apply their interpretation of the Bible. Of course, in Paul, the court says if an ex-member is physically assaulted or beaten, that is still a crime. There is no religious liberty defense. But the fact that other members, including their relatives, will not speak to him or her, in this case, it's not something the court can decide. Of course, it may be an offense to modern sensitivity, but there is an interesting comment in Paul: without society's tolerance of offenses to sensibility, the protection of religious differences mandated in the US by the First Amendment will be meaningless. So all was said in a way in 1987. It was reiterated in a case against two, or promoted by, but decided against two well-known apostates, the Anderson by the Court of Appeal in Tennessee in 2007. Courts are not empowered to force any individual to associate with anyone else. Shunning is a part of the Jehovah's Witnesses belief system. Individuals who choose to join the church voluntarily accept the governance of the church and subject themselves to being shunned if they are disfellowshipped. And there are not only decisions in US, I mention here a case in Germany in 2010, one of the Italian Supreme Court in 2017. You will find them in the white paper and also in the text of this speech to be published in the Journal of Cesnur. The point is, all these decisions have recognized shunning as part of corporate religious liberty of Jehovah's Witnesses. Of course, it can be painful, but other things are painful too. If a husband and a wife divorced, in an ideal world, they should remain in civilized terms. But if a wife decides to shun the husband or vice versa, and not to speak any longer with the spouse, the court cannot compel a spouse to continue to associate with an ex-spouse. They cannot compel members of a political party to associate with somebody who has left the political party and they can feel he or she is a traitor. And we know that often that may happen even within the family, certainly in the case of a divorce. So we, courts of law, cannot order individuals to associate with anybody else, and they cannot prevent Jehovah's Witnesses from teaching that shunning is biblically mandated, because that will interfere with the corporate religious liberty of Jehovah's Witnesses. As for the individual religious liberty, as Anderson and the German case say, at the time when you join the Jehovah's Witnesses, you know there is a risk of being shunned if you are disfellowshipped by the church, by the congregation. And so in the moment when you voluntarily join the Jehovah's Witnesses, you assume this risk, and even if you are born into the Jehovah's Witnesses, of course, you can leave, or if you don't like the Jehovah's Witnesses. So your freedom again is to establish a different religion whose rules you will like better. Your freedom is not to compel congregation to change their biblical interpretation or practices resulting from this interpretation. I go to the other point, sexual abuse, because recently we have seen commissions or other bodies mandated by governments in Australia, Netherlands, Belgium. Holy Folk will talk about it, criticize the attitude of the Jehovah's Witnesses about cases of sexual abuse within their members. And even we saw a cabinet minister a few days ago in the Netherlands criticizing the witnesses. I believe here there is a confusion which should be dispelled. If you are a Jehovah's Witness or a Roman Catholic or a member of any other religion, you are one person. There is not two of you, but you are subject to two different jurisdictions. As a citizen, you are subject to secular courts. As a Jehovah's Witness, you are subject to the judicial committees. If you are a Catholic, you are subject to canon law, and so on. And these two jurisdictions are totally different. So when elder or a congregation in the Jehovah's Witnesses receives a report about sexual abuse, at this very stage, the congregation has two duties. Duty number one is to secular justice, and they should report to the secular justice according to the national laws, which are very different from country to country. And the second duty, if the rumor is serious, is to investigate the member and decide whether the member should be disfellowshipped by an internal judicial committee. Now, this point is totally crucial. You should not confuse the two jurisdictions. So, the Jehovah's Witnesses publications mandate that national laws should be obeyed in general, and national laws should be obeyed when sexual abuse is reported to secular authorities. And again, in the white paper in part and in the written article, you will see more quotes, but there are scores of quotes dating back actually to many years ago, saying that while in general Jehovah's Witnesses do not advise to take their internal problems to secular court, in case of a serious crime such as sexual abuse, each member has a right, and if national laws mandate it, a duty to report to secular authorities, and nobody is criticized, let alone disfellowshipped, for reporting a case of sexual abuse to the authorities. Now, Holly Falk and Gordon Melton wrote an answer to a report commissioned by the Dutch government, and our answer has been kindly publicized by the same Dutch government in their official website, where we point out scores of text by the Jehovah's Witnesses saying national laws should be obeyed. If your national laws are bad, it's your problem, not the Jehovah's Witnesses. And that nobody is criticized or disfellowship for reporting sexual abuse to secular authorities. And the answer we got from the anti-witnesses organization, which first started the process in the Netherlands, it's okay. It's all very beautiful in the books, but how can we be sure that all local congregations follow what's written in the book? And that's a valid objection, but it's not valid against the Jehovah's Witnesses only. And if what is written in the book is valid, the problem is not with the indication or the structure of the Jehovah's Witnesses. The problem is in the fact that no human organization is made only of perfect human beings, and sometimes human beings, even if they have the best possible laws, they do not apply it. It's also true that some cases where Jehovah's Witnesses have been criticized are old cases, and cases where the sensitivity to sexual abuse in society in general was lower than it is today. And I quote a case in UK where in 2015 facts were judged dating back to 25 or 20 years before. And in the end, the judge found against the Jehovah's Witnesses, saying some mistakes were made back in the 80s and early 90s. But at the same time, the judge praised the Jehovah's Witnesses, saying their internal rules were ahead of the time if compared to other religious and non-religious organizations. So their rules were already good 20 years ago. And yes, it's still possible that some cases go unreported, but that happens in large churches, as we all know, and it happens in secular organizations dealing with children as well. Now, I want to insist, and I'm going to my conclusion, that we should not confuse how the Jehovah's Witnesses deal with sexual abuse when the issue is whether and when to report to secular authorities. They comply with the national law in general. If in some cases they didn't, that's part of the mistakes which may happen in any organization, but it's not due to the rules. And by the way, it was less frequent among witnesses than among some larger religions. This is one problem: sexual abuse, secular authorities. But there is a different problem: sexual abuse and judicial committees. Should the abusers be expelled? And here we should recognize that divine justice and human justice is different. If you are a Christian, you know the story of the good thief, and there is a whole medieval literature on the lateral penitence in Latin. When Jesus was on the cross, there were two thieves, and one of the thieves told Jesus, I'm here and I'm rightly punished because I'm a criminal, but you are innocent, and I would like to be in your kingdom. And Jesus say, yes, I told you, you will be in my kingdom. So the good thief was such a good thief that he was even able to steal eternal salvation. But what is important here is that in the author of the Gospel of Luke is not criticizing Roman justice in respect of the thief. There is no criticism of death penalty either, but there is a very strong emphasis on the fact that human justice is one thing. Human justice was right to sentence the thief because he was a thief. And on the other hand, religious justice is different. And the Catholic Church has even canonized as a saint the good thief, calling him Saint Dismas. So divine justice, religious justice can take into account things such as repentance, which are taken into account by secular courts only as a mitigating factor, but don't change the verdict. Now, we read in some official reports, including the Royal Australian Commission, some strange comments. They asked the Jehovah's Witnesses to change the two-witness rule. George Chrysides mentioned it, or even to include women in their judicial committees. But that's, again, it's a breach of corporate religious liberty. Because while the state have a right to enact laws compelling religious bodies to report to them, to secular authorities, cases of sexual abuse, again, they have no right to decide how judicial committees should proceed and whether alleged sexual abusers should be expelled or not. That is within the religious liberty corporate of Jehovah's Witnesses and the sphere where the state cannot enter. Of course, in the case of the Catholic Church and others, it has been said that if priests accused of pedophilia are not expelled, they will still approach children in catechism or Sunday school or boarding schools, but that doesn't apply to the Jehovah's Witnesses because they do not have such institutions. In conclusion, I want to mention the controversial Pompeo Commission, the US Commission on Unalienable Rights, established by Secretary of State Pompeo in 2019, which has just released its draft report. And Pompeo asked, there are so many human rights, which are more important or unalienable? And the move was widely criticized as an attempt by the Republican Party to promote religious liberty at the expenses of LGBT rights or reproductive rights, that is, right to abortion of women. So I don't believe the Pompeo Commission would be unanimously accepted, but of course the problem is real. There may be a conflict between human rights, which human rights should prevail. And the Pompeo Commission made an appeal to the American Constitution, which may be valid in the United States, but certainly not elsewhere. And a more safe solution will be to prioritize human rights explicitly mentioned in the Universal Declaration of Human Rights versus those not mentioned there. That doesn't mean they do not exist, but until the international community can come to a new consensus, I believe the rights explicitly mentioned in UDHR have a certain priority. Now, that is contested by Russia and China and by some scholars by saying that the UDHR is a Western and Protestant document imposed by the US to the rest of the world, but scholars have proved that's not true. You may read in many books or perhaps in Wikipedia that the document was drafted by Eleanor Roosevelt and French René Cassin. But if you go beyond and look at articles written by scholars who digged more deeply, you will see that the main drafters were Charles Malik, an Arab, Eastern Orthodox Christian. You see him above, delegate from Lebanon, and Chang Pen-chun, who called himself a Confucian and was a representative of China. Of course, at that time, China was Taiwan. And also scholars have noted that for many years, the US were not very active in promoting the Universal Declaration of Human Rights, and particularly conservative American politicians saw it as a dangerous document that may eventually submit the United States to censorship by forces and countries outside the United States. So I believe the Universal Declaration of Human Rights is indeed more universal than some, including in Russia and China, will want us to believe. As for the well-intentioned drafters of the Pompeo Commission document, I would say that the risk is that by focusing, as they did, on individual religious freedom, although that's still a problem in countries such as Russia or China, but focusing only on individual religious freedom involves a risk of not seeing the forest for the trees. What is at risk today in democratic countries is corporate religious liberty. Individual religious liberty is more or less accepted. And of course, I answer an objection, the two of them are connected. So we can say that by defending their rights to operate judicial committees free from state interference, to interpret the Bible in the sense that it mandates shunning those who have been disfellowship, and in deciding autonomously whether those accused of sexual abuse should be disfellowship or not, which again is a different problem for reporting them to state authorities, but by fiercely asserting their independence, the Jehovah's Witnesses are again defending the religious liberty of all religions, and particularly they are defending it in the area corporate religious liberty, where today it is mostly under attack. Thank you, and you may read the full version of this lecture in November in the Journal of Cesnur.